Our topic today, we handle the expert evidence in construction arbitration. Today we can see the expert evidence in every construction dispute, but sometimes the arbitrator say the expert doesn't have. And today we are discussing how to select the right expert, how we structure the procedure so the expert can be helpful. And we also discussing something new, the Singapore SCL protocol on uh, joint expert statement. Today we have three speakers who will speak on three views. Mr. Frederick from legal view, Miss Leslie from practice view, and Miss Chang from technical view. So let's welcome Mr. Frederick. And first, I would like to introduce a few words about Mr. Frederick. Frederick is a partner of Pinsett Manson. He has over 25 years in construction law. He handled everything from project support to major dispute, covering infrastructure, transport, water, and energy projects. He qualified as both a solicitor in England and Wales and a lawyer in Paris Bar, and also a certified FIDIC adjudicator. He directed LLL program in international construction contract in Pantheon Asa University in Singapore, and also teach the same program in Paris. Who legal describe him as having an encyclopedic understanding FIDIC contract. So if you have any FIDIC question, he is the right person. Okay, so let's start.
Thank you. Good morning. Thank you very much for the kind introduction. You mentioned the LLM, a bit of publicity. So we've launched this LLM in international construction contract in Singapore 3 years ago. The applications are open. So if any one of you is interested in getting some details about the course, please reach out to me. Today, we're going to talk about how to manage expert evidence effectively in construction arbitration. I think the whole session will be about expert evidence from different point of view. As we all know, expert evidence sits at the heart of construction arbitrations. Yet, arbitral tribunals sometimes criticize experts and expert reports as being sometimes unfocused, sometimes not terribly helpful for the tribunal, or even actually sometimes partisan. That's the worst. So the question for today is not whether expert evidence is useful to tribunal. It's essential, in fact. The question is how to manage it effectively so that it's most helpful to tribunal. So what we'll do, we look at first. Here we go. Why expert evidence sometimes fails tribunals. And then we'll look at or examine practical tools to manage expert evidence across the life cycle of a construction arbitration. We look in particular at some issues with midstream CMCs, construction, the case management conference, but also we touch upon joint statements. But I won't say too much about it because there will be an entire session about joint statements. So without further ado, let's start with our first topic, which is why expert evidence sometimes fails tribunals. The short answer is because it does not reduce complexity. When we deal with construction arbitrations, tribunals, sometimes we are not specialist construction arbitrators, are faced with very complex issues. And I suppose the essential role of a tribunal, an expert, is really to make things intelligible, understandable to the tribunal. And when it comes to why sometimes experts fail tribunals, it's because they make things even more complicated. So I think that's the first thing. And in terms of delay cases, for example, we have sometimes some issue that arises from different factual records not being shared between the experts, different assumptions, different methodology. Obviously, if you have a delay expert who is not proceeding with the same critical path, it's really difficult to compare the analysis and the conclusion. So having something which is towards a joint methodology, an agreement on methodology is important. When there are differences, and there will be differences sometimes, it's important for the tribunal to understand that more than just there's a debate about the methodology, but what is the impact of a different methodology or different assumptions on the decision that the tribunal has to make. And very often what we see is that experts will probably disagree, but without explaining the impact of their disagreement. But ultimately, you need to select the right experts. And I think when it comes to the choice of experts, and I think there's quite a few experts here in the room, they probably will agree with me, but the issue sometimes is we find experts who are sometimes perceived to be too aggressive or too prolific in terms of production of their expert reports, which sometimes turns into hundreds of pages of documents in their reports. So what are we looking for when we're looking for the right experts? Obviously, the expert will be there to support your case, but not necessarily to be advocating the case. And sometimes we'll come back to that in a moment. Sometimes there's a common mistake that your expert should be really there to not only to defend your position, but really to advocate it. It's all about credibility. And I think when it comes to joint statements, the exercise is very important. And I have to say, sometimes legal counsel like myself, may make the process unhelpful for tribunals, because precisely we should help the expert narrowing issues for the tribunal. And that may come through conceding points, which sometimes for clients may not be so appealing. So let's spend a bit of time about tools to manage effectively expert evidence. I should maybe mention at this stage a pretty important document that was produced by the ICC, first in early 2000 and then in 2019, entitled Recommended Tools and Techniques for Effective Management in Construction Industry Arbitration. Initially, it was designed to help tribunals who are not construction arbitrators, but it's really of generic use and beyond ICC arbitration. And it contains some helpful tips and guidance for any arbitrator and also counsel when managing experts. One interesting feature, which we'll visit in a second, is the use of midstream CMC and then joint statements. Midstream CMCs is something that is unfortunately not used enough. Typically, this is something that you would discuss at the beginning of a case, when you have your first case management conference with the tribunal. People will talk about the timetable and also the involvement of experts. And more often than not, what you see is experts being mentioned at the end. Yeah, there will be some experts meetings, let's say at least a month before the hearing, and then you produce a joint statement or something like that. That would be one line in the procedural order number one, but without details as to whether there would be joint meetings before. And I think the CMC is the right time for the tribunal to get a grip on the issues of the case. Obviously, it comes midstream, so you would normally have it after the first round of pleadings. So statement of defense, at the beginning of the disclosure phase, there may be issues to do with disclosure. So midstream CMC may help in deciding these, disclosure issues, but also to decide what to do with some of the key issues identified in the case with the experts. And I've seen, good tribunals, hands-on tribunals who have a good understanding of construction law issues, insisting that experts start to meet immediately after the first round of pleadings, which sometimes may be a bit nerve-wracking for parties because their case may not be so clear even at that stage. But I think it's important for the tribunal to start realizing what the issues are about the case. If there are issues with, I'm talking about quantum, for example, with the data, the reliability of a cost ledger, this is at that point you can actually get the experts to agree on the set of data that we're going to look at. for delay, obviously looking at critical path, the methodology. It has to be done now. Otherwise, if you wait until a month before the hearing, it will be far too late. Now, looking at John's statements for a second. John's statements is a pretty well established, again, line in the procedural order number 1, where it said that parties experts should meet to then produce a statement of points agreed or disagreed. The issue sometimes is that it may be a very limited document which will simply say facts that are disagreed or methodology assumptions that are disagreed without specifying the impact that disagreement may have. And when it gets to point agreed, obviously sometimes it's very minimal. And I think getting experts to engage early on would help probably having a better understanding what the issues are for the tribunal that they need to decide. So I think it's a very important exercise. And I think the SCL protocol, which was published in January this year by SCL Singapore, has done a very good job at explaining the importance of the document, something that was used commonly, but providing some guidance as well for the tribunal with some draft template of procedural orders. So a really good document. I encourage you to look at. And it's got then some core objectives or principles, which sometimes may be idealistic. We'll come back to the role of counsel in the joint statement process, but otherwise there's some good principles that are set out in this SCL protocol. Reduce expert advocacy and improve transparency. This is all about having experts that really truly meet without the interference of counsel, so that we can really truly have something that is of some use to the tribunal. What we see commonly is the joint statement process being hijacked by counsels, and to the effect that you have a repleading of the case in that joint statements with new documents being produced, new arguments, new position being taken by parties. And that's often the result of having that joint statements process taking place very much at the end, a few weeks or 2 or 3 weeks before the hearing. At that point, everything has crystallized. We know where the issues are. And this is a channel for parties to replead their case or introduce new documents. So that shouldn't be allowed. So the SCL protocol does set out, that it should take place after exchange of expert reports, before the hearing. I think what the SCL protocol should do is also, or we should have in mind, is that should take place much earlier than just before the hearing. So how does it work, this joint statement? I'm pretty sure some of you have been involved in the process, but typically you would have experts meeting. They would be without counsel involved. The counsel would sit in the background sometimes, just make sure that everything has been done and nothing has been conceded too quickly. Maybe we can pause here on concession, because this one thing that I found sometimes disturbing clients when selecting experts. We obviously want an expert who is strong enough, assertive enough to convince the tribunal of the robustness of the case, of the arguments, of the assumptions that have been made. But there's sometimes confusions about a strong expert and someone who is advocating a party's case. And I think this is where I think there's a bit of explanation that needs to be done. A strong expert, in my view, is someone that's really credible to the expert, someone who would come across as being not advocating the case, but truly helping the tribunal. And this is sometimes we've seen. So we talked about it yesterday. There was a recent case in Singapore, in the UK, with an expert, technical expert from Singapore. And that expert had made some assumptions in his reports. He's made some use of data, but probably more selectively than he should have been. And that transpired the hearing. And there was a number of concessions that he had to make that he should have done early on. He should have probably done an alternative analysis faced with an argument raised by the other side expert. But instead of doing that, is essentially ignored the downside to his client's case. And that came out at the hearing to the point that the judge took a very critical eye on his report, ignored it, but actually was very critical personally of his work, asking him some questions about, for example, why haven't you explained that method in terms of the technical issue that was involved? There was cement, and the expert got a bit crossed and said to the judge, well, you should Google it for yourself. You will know what this methodology is all about. Obviously, the judge didn't like it very well. And then there was many concessions made, and you could see that the concessions made at the hearing is a bit late, and that affects the credibility of the expert. But otherwise, I think going back to the joint statements process, very important process. If it's done properly, it really helps the tribunal to narrow issues. And what's important in that document is that the tribunal provide guidance as well. And things that we don't see very often is, the experts being guided by the tribunal as to what they expect. Again, I think it's part of our job also as arbitrator to make sure that at an early stage, the experts are guided, encouraged to meet, and for a proper deliverable, which will be this joint statement, a particular format that they want. Role of counsel, I've mentioned it already. The idea for the counsel is not to drive the process. We do see sometimes when joint statements are prepared at the very end of the case, wording being literally, provided by counsel. I think it's useful, but because they have a good understanding of the case as a whole. But obviously, it's something that needs to be addressed is when experts are completely steered by counsel, because then the process is losing its usefulness. Now, moving on quickly to another thing is the hearing. Obviously, very important time for experts. They take the stand, their credibility is tested, and this is where it all starts sometimes to collapse. The expert that is being partisan, usually at the hearing, this is where it's become very, very clear. And what you see is obviously beyond the cross-examination by counsel, you see experts being examined, asked questions by the tribunal with this expert conferencing system, which is well established. I see pretty much all the time. But its usefulness varies depending on the level of preparation of arbitrators. You need someone who is a tribunal that really is hands-on with the issues, and be able to properly test the methodology, the facts that have been, or the data that has been used by each party expert. So I'm pretty sure we all know what witness conferencing is, so I'm not going to drag about it. But it's a useful exercise. Sometimes it does help the tribunal, even if the tribunal is not fully prepared. And this is where you see the limits of the exercise, when you see tribunal asking some very, very basic questions to experts about, can you just clarify what it means critical path? Then you start having, this line of question, you understand your tribunal is not fully prepared. So when does it add value, this witness conferencing? Is, I think, when there's been precisely a lot of preparation between both experts in narrowing down issues, identifying the points of disagreement, because once you have this list of issues, this joint statement process properly done, you get effectively a live roadmap for the tribunal to go through what are the points on which you disagree, the fundamental issues in dispute that you disagree on. And then that helps the tribunal asking the right questions. And even if the tribunal is not fully prepared, or even if your joint statements process has not delivered anything useful, it's useful as well for the tribunal just to test the credibility of experts. And I think it's something that they find useful as well. Joint statements, when it's well prepared, as I said, it provides a roadmap. So I think that's where I found the best situation where witness conferencing is actually of use. And then professional judgment, I think, when tribunal find hot topping particularly valuable is when they have assumptions that are probably not agreed totally, so they can test the assumptions that are being made. And they can also test as well the conclusion that each expert has made based on the inputs. And again, they can test as well the data set that has been given to the expert. And again, going back to this case I mentioned earlier, when pushed, the experts had to say, well, yes, it's true, my conclusions are probably selective, but that's because I've only been given this set of data by my instructing solicitors. And you can just see that this is not good enough for an expert to just rely on the information given to him by his instructing solicitor or lawyers. He needs to go beyond that and ask for further information. So that was interesting at the hearing that the tribunal, or in this case, the judge realized that we had a pre-partisan expert. And then finally, post-hearing involvement, something that is quite debatable. And if you have any views, I'd quite like to hear it, or maybe our co-panelists may have a view, whether experts have a role to play after the hearing. Something I see very rarely. I've seen it twice, in fact. It's where sometimes the witness conferencing has been useful, but incomplete. And you find the tribunal, with, wanting more in terms of input from the experts. Sometimes it's also because when asked to determine an extension of time, there may be tweaking to be done to the analysis of one expert. And, we need to recognize that even construction arbitrators are not experts. And when, playing with some very complicated softwares, or even actually an Excel spreadsheet, it may not be the best skill set for a tribunal. So having the ability to rely on experts post-hearing to essentially tweak their decision, as in refine the decision, it's useful. Quantum as well. When it comes to calculation of interest, you see experts, doing this very complicated Excel spreadsheet, and you would think that we just need to put one figure and everything is calculated. It's not so easy. And having the confidence that, we can talk to an expert, the party's expert, without the party's counsel involved, to make sure that our calculation is right, is, I think, something that is underused and could actually avoid having what we see more and more, which is rectifications of awards. So when some tweaking has been done by the tribunal based on the expert reports, complicated expert reports, sometimes they make errors, and this is absolutely fine. But one way to avoid errors being made is for tribunals to be able to have access to experts. And I think what we see as well is, in that context, the use of expert access protocols, so something which is well designed at the outset and agree between the parties in terms of access to expert post-hearing. I think have I gone overboard in terms of time, or are we good?
Okay, you can spend 1 minute.
1 minute for practical takeaway. So it's just to repeat what we've seen, but essentially the key message is obviously expert evidence should, as we say, reduce complexity, not increase it. And, sometimes for big complicated cases with hundreds of pages, with 3 rounds of expert reports, sometimes with 3, 4, 500 pages of expert reports. Sometimes for the tribunal, it can be a daunting exercise to digest everything. Obviously, with ChatGPT helps, but I don't think that's the answer. The answer is really for experts to help the tribunal deciding issues that are truly in disputes. And it's also down to the tribunal to insist at the outset for experts to be truly helpful, so guiding them, making clear their expectations in terms of guidance, in terms of involvement, probably at an early stage in the process, probably after the first round of pleading, so that truly they help the tribunal decide the key issues and disputes. I think that's it for now. So any question, I'd be happy to answer. Thank you.
Thank you, Mr. Frederick. So the next speaker is Leslie Tan. She's a partner of in Partnership Singapore. She focused on energy project, construction dispute, and she advised developer, contractor, and consultant in litigation, arbitration, and adjudication, particularly on complex high-state infrastructure projects. Her client her client include Land Transport Authority, Changi Airport, and SMRT. Her work includes tunnel, rail, airport terminal, power plant, and large residential and commercial projects. She recognized by Legal 500, Chamber, and IFLR 1000 as a leading name in project development and transport dispute. So please welcome Leslie Tan.
Thank you, Nan, for the kind introduction. While he's highlighted my roles in Wong Partnership as a construction practitioner and sometimes sitting as an arbitrator, today I come wearing the cap as a council member of the Society of Construction Law Singapore. And I'm very proud to share with you the work product that the society has worked hard on, culminating in the protocol for experts' joint statements, which Frederick the protocol and also bring you through some of the industry pain points that the protocol was developed to address. And we will go through the core principles that are addressed in the protocol. And finally, some practical takeaways on how to adopt the protocol in the course of your dispute resolution processes. Okay, moving on to the overview. I'll provide you some background as to how we developed the protocol. In January 2026, so that's just 3-4 months ago, the Society released the protocol for the use of experts' joint statements in arbitration. This was in recognition that expert evidence is a cornerstone of construction dispute resolution. And in terms of the drafting timeline, we started as early as January 2019 when we first published an article, and there was a lot of interest in the topic. And in 2019, 2020, the Society conducted a survey of the construction and arbitration community. And a great majority, some 95% of the respondents actually supported and thought that drafting such a protocol would be useful. So the working group under a thought leadership committee was formed to initiate drafting such a protocol. And so in 2024, 2025, the past 2 years, the Society then worked closely with various stakeholders in the industry, experts, consultants, individuals, organizations, and arbitral institutions to provide further comments. And we then took on the feedback and incorporated it in the draft. When we launched it in January, this protocol, I think, has been well received. And I should flag that we are continuing to take feedback as you consider the use of the protocol in your practice. Do share this with us. And the Society is looking to take in any useful comments or adaptations in our next edition as appropriate. So let me share with you the comments from the Justice Philip Jeyaretnam. He's the president of the Singapore International Commercial Court and also, incidentally, the founding chairman of Society of Construction Law Singapore. And he, of course, recognizes that dealing with expert evidence efficiently and effectively is one of the most important tasks of case management. And he commended the launching of this protocol. There was some discussions at the launch, and just also sharing with you the number of organizations in the next slide that were invited to contribute to the protocol. So as you can see, we tapped on feedback from the SIAP Singapore branch, the Tunneling and Underground Construction Society, Society of Project Managers. So there really was feedback across the spectrum of the industry stakeholders. And we don't gatekeep, so feel free to access the protocol. The full text of the protocol is available on the SCL Singapore website. Next, I'll bring you through some of the industry pain points that we sought to address. First being the issue of perceived or actual partisanship, where we have situations where party-appointed experts may sometimes consciously or unconsciously align with their appointing party's case, notwithstanding that their first and foremost duty is to the court or tribunal as independent experts. So this then causes a focus shift from analysis of issues to allegations of bias, which then wastes precious time and resources in the dispute resolution process. So one example of perceived or actual partisanship was in the High Court case of Gunapati, where the High Court addressed the issue of testimony given by skilled witnesses, because the expert witnesses that we're talking about. And there were some pretty harsh words. The perception was they do not willfully misrepresent what they think, but their judgment becomes so warped by regarding the subject in one point of view that when conscientiously disposed, they are incapable of expressing a candid opinion. They were also being described as zealous partisans, where their belief becomes synonymous with faith. So this could rile some of the experts in the room, but that is some of the perception issues. Another case, this was a High Court decision that was later affirmed on appeal before the Singapore Court of Appeal. The JSI shipping case involved one Mr. Singh, who was a defendant's expert witness. And in that case, the court found that many aspects of Mr. Singh's evidence was rather partisan and not objective or independent, as to be expected from an expert. So three principal concerns were identified. First, Mr. Singh made sweeping generalizations in his report, where he asserted it would be impossible to detect certain fraudulent practices. And then he demonstrated an inclination to make assumptions and suppositions in the defendant's favor without the adequate factual basis that was supporting it. And finally, I think an egregious point was that an expert selectively quoted from the relevant Singapore standards on auditing in support of his conclusions, but deliberately omitting various qualifications within those same provisions that he cited. So all these deficiencies taken together led the court to conclude that these significant portions of the expert testimony was tailored to prop up the respondent's cause. And really the nail in the coffin was Mr. Singh's own concession under cross-examination that he truly had no basis for certain allegations made in his report. So these are deeply both embarrassing and also drain on resources and time of all the parties involved. So this was something that the protocol seeks to address. Next, we have the issue of divergent starting points and unequal information. As we all know, the traditional process provides that experts are briefed separately by their own the parties that have appointed them, and they may therefore rely on different assumptions, data sets, or documentary access. And as a result, then significant hearing time will have to be spent to reconcile the factual basis on which they founded their analysis before they can even properly assess matter on a technical basis. Another issue is the misaligned framing of the issues in dispute. The experts may define their questions differently instead of looking at the same question, the same starting point, and therefore they could apply their different methodologies or structure their reports in incompatible ways where the tribunal reading it or counsel reading it cannot compare apples and apples to assess the respective merits. Therefore, opinions would then be difficult to compare and experts talk past each other. Procedural inefficiency, as we've mentioned, is another issue, and particularly in the context where instead of a joint statement, if you have two independent expert statements, you would have potentially duplicated analysis, overlapping aspects of their reports, and you spend a long time cross-examining the reports on different bases, and the joint expert statement typically comes quite late in the day rather than from the get-go. This escalates costs without any benefit. Next, we have the issue of a lack of structured case management, where lacking a protocol or the procedural orders, the extent of the lawyer involvement may not be clear to all parties, and therefore causes the scope of expert evidence to be unclear. And in the absence of this early direction, this expert evidence may then have the counterproductive effect of making the issues become more complex. Okay. Leave you with some observations from a Court of Appeal decision. And then I'll dive in straight to the core principles that's addressed in the protocol. The experts, the first principle suggests that experts providing a joint report should have a declaration in that joint report. And that declaration, there are various aspects that parties can tailor to their needs, but this is a sample, the template that's recommended under the protocol. And this would include that everything they've stated are within their area of expertise and has not been influenced by any party. So is this just face value, and what is the effect of this declaration? Having made such a declaration in their joint report, if it then later transpires, perhaps during the hearing, that the opinion or testimony of an expert is not in accordance with what they have themselves declared or set out in the declaration, the tribunal can actually disregard that expert's opinion and testimony, either in whole or in part, or give it lesser weight. So what you see here on the slide on the right is the form of the expert's joint statement that's been annexed to the protocol, and the terms of the declaration that's recommended is also set out in this form. Principle 2 of the protocol addresses the issue of communication between experts for the preparation of the joint statement. And of course, party autonomy then translates to experts being able to communicate freely, to comprehensively discuss issues. And the protocol further provides various guidance about this communication. I think one of the foremost points being that unless ordered by the tribunal, neither parties nor their counsel should attend. But if you do have counsel attending these, there are various considerations that's also set out in the guidance. Principle 3 of the protocol provides that parties and their counsel should not seek to influence their respective experts. I think that's a real touchstone of the protocol as regards the contents of what they were setting out in the joint statements. And in the guidance notes, there is also again stress that the parties' counsel must not be involved in the negotiating or drafting of the experts' joint statement. I think this is to address the issue where sometimes you see experts' reports coming back, very much reading like counsel submissions. Principle 4, there should not be any unilateral communications between an expert and the tribunal. All communications should be sent to all experts. So similar to communications between counsel, there should not be independent ex parte communications between the tribunal and experts. There are also a proposed list of directions for guidance to arbitrators in this space, where tribunal can give to experts any directions for conferences outside of the hearing, and also give directions as to the stage at which the tribunal finds that it will be useful to receive such a joint statement. So the list runs longer than this, but I'll leave you to explore the protocol. Mm-hmm. And also principle 5, we have the consultation between the experts and how to address or align their methodology. While the principle recognizes that the traditional approach is where the tribunal requires experts to file their reports and then proceed to conference, we open the idea that the sequence depends very much on the nature of the case, and it may well be that the case requires a alternative approach. This could be using pleadings first, or memorials procedure, and then allowing for earlier engagement between the experts and having a first experts joint statement prior to the experts having their respective reports. Principle 6 covers the content of the joint expert statement to narrow the issues in dispute, and where the experts are unable to reach an agreement, then that expert should provide reasons and as to why that expert disagrees with the other expert on the issues. Okay, as Frederick mentioned, post-hearing issues are rather rare, but on the occasion, sometimes the hearing itself may surface questions that the expert evidence had not fully resolved or clarified. So bearing in mind the possibility of such a situation, the Principle 7 provides that the tribunal should be free to actually consider approaching the experts to ask that the experts confer further on any particular issue and try to reach an agreed outcome on those matters. Okay, again, we have some guidance supporting that principle. So I wanted to share with you the form of tribunal instructions that can be given to experts. So the protocol annexes this form, and it may be a little bit blurred, but if you look at the document itself, it sets out a framework where all experts will then show, the joint expert statement itself will highlight what are the instructions given to the experts by the tribunal, the instructions given from party A, and the instructions given from party B. So this sets a framework where all parties are aware what is the framework of the instructions or the parameters in which the expert was asked to prepare his report. I think this would potentially give a deterrence effect where instructions could cross the boundary between a factual briefing to partisan influence if such a disclosure was given in respect of the instructions given to expert. And also, having such a disclosure actually provides the, all experts framework to understand what were the terms given on which the report was prepared. Next, we've also been very helpful to support the arbitral tribunal to incorporate the protocol with proposed model language to for tribunals to then put in the form of a procedural order that they are incorporating the use of this protocol. And there is also a model clause on how an order may be worded for the preparation and submission of the expert's joint statement aligned with the protocol. And finally, we have a form of expert's joint statement. And okay, this is the description of what it should look like. And this is what the schedule looks like. And what we have is the description of the issues, and then the parties, whether they, the experts are to identify whether they agree or disagree. And if there is a disagreement, each party is to set out the reason for why it is unable to reach agreement, or how it departs or differs from the other expert. Finally, how we propose to have the practical adoption, apart from already feeding all these model clauses and templates to really ease the adoption of the protocol, we do recommend that these protocol be integrated early in the process rather than later, so that they are captured within the initial procedural orders. And really, we ask and urge that counsel and experts alike involved in the arbitral process to adopt the mindset and the spirit of the protocol. Finally, in terms of flexibility, I think doing so will customize the framework to suit cases of varying complexity. And absolutely, I should add that parties do have flexibility on how they wish to adopt the protocol. It doesn't have to be lock, stock, and barrel. And parties are free to agree to apply the protocol, whether in whole or in part. All right. So in conclusion, we have the protocol is not just a document that's to govern procedure. Really, it is to try to give stakeholders a tool to reach a consensus and make the arbitration process more smooth and more efficient. So I'll leave the time for questions. I'll be happy to address any questions you may have. So in the meantime, as I urge you again, when you do consider the protocol and you have feedback, feel free to contact myself or other members of the Society of Construction Law Singapore. Thank you.
Thank Leslie. So the next speaker is Chang. Chang is a delay expert and manager in Secretariat. She specializes in delay analysis, and she works on dispute across UAE, Qatar, India, Hong Kong, Singapore, Malaysia, Indonesia, Vietnam, under the rules of ICC, SAIC, and DAIC. So she has a civil engineering background from National University of Singapore and Master of Law in Robert Gordon University. So Chang can bring both technical and legal knowledge to construction dispute and to her presentation today. So Chang.
Good morning, everyone. My name is Trong, and as introduced, I'm a manager at Secretariat based in Singapore. My background was in civil engineering, and my work mainly focuses on the technical aspect of the construction disputes, in particular, delay analysis and assisting experts during formal arbitration proceedings. So I'm very happy to be speaking alongside our esteemed panelists today who have shared their insights on expert evidence. In my presentation, I'm going to talk about technology and expert evidence in construction disputes. So technology is quite a familiar topic, and it's been recently heavily discussed. In the midst of those discussions, which can sometimes be quite abstract. I think it's very important for us to take a step back and recognize that improving the quality of our work doesn't have to require the most advanced technology, but rather a better understanding and a better use of the tools that we already have, while also being aware of the new technology. So with that in mind, my presentation today will cover three main parts. First of all, I'm going to establish the link between digital transformation in construction and the changing nature of the information, which eventually become the evidence in construction disputes. After that, I'm going to talk about the use of existing technology across different stages of expert work. And finally, I'm going to touch a little bit on the emerging role of artificial intelligence in light of a recent guidance from the Academy of Experts. So I'd like to begin with a very simple comparison between the past and the present of construction technology. This comparison actually comes from a recent conversation between me and my colleague, Dr. John Lancaster. So John has over 40 years of experience in the construction industry, and he often described his early years on site where everything was done on paper. Drawings were produced by hands, and his entire office is full of physical documents. If a client changed their mind, he mentioned he basically will have to use a razor to scrape off the ink from the drawings and then manually draw the line again. So that's how time-consuming everything was. In contrast, when I joined the industry about 8 years ago, and also during my training as civil engineer, things already looks very different. Most project documents were stored in electronic file and backed up on cloud, and we no longer have to manually do the change by hand, but we can do the change on computers, and this change can be reflected almost instantly across different drawings, different models and programs. So as you can see, even though construction industry is known to be quite old-fashioned, but it's already changing gradually. And to give you some numbers, in a recent survey of over 800 companies, construction and engineering companies, it is shown that there is a 20% increase in digital adoption. And on average, firms report using over 6 different digital tools in managing a single project. So the most commonly used tools are building information modeling, BIM, common data environments, CDEs, Internet of Things, smart sensors, and mobile apps. So just to give you a few names, if you come across them. Broadly speaking, construction industry has evolved from using standalone application towards a more integrated ecosystem. And this has really enabled the contractor, the employers to be able to work on the same environment and to access the same information with efficiency. However, we do face a lot of challenges, and this is because the adoption is not even across the industry. And we see a lot of companies adopt technology, but in very limited department or across fragmented system. And this has created a lot of information silos, as well as difficulties in managing and interpreting project data. All these observations are really the context for the discussion today, because technology has not only changed the way how project is managed and delivered, but it also changed the way how project information was generated and eventually how disputes are dealt with. That will bring us to the second part of this presentation. So from an expert perspective, we are now in an age where there is abundant information. However, more information doesn't mean better evidence. And the challenge is no longer just about getting the information, but it's also about using the right tools to manage and interpret those information and then how to communicate those in the most reliable and transparent way. In order to understand the interaction between technology and expert work, I've put together a very simple chart showing you the 3 typical stages of expert work in general. The input stage is basically about getting and managing large volumes of project documents, followed by the analysis stage, where it's about using the simulation and modeling tools to interpret project data. And finally, it's about the communication between the expert and the tribunal or the court. Let's start with the input stage. This stage is all about data. So just like with any profession, effective data management is fundamental to the accuracy and the efficiency of your work, right? So with expert, it is worth noting that usually project documents are generated over years and years of project life cycle, but the expert would only have very limited time to review those documents, sometimes even in weeks. So technology can really help to address these challenges. Taking delay analysis as an example, a very common exercise that we usually carried out is that to gather as-built information from progress reports, and this can come in varying formats and different level of details like PDF or spreadsheets or scanned documents. So a good starting point is always the basic tool like Microsoft Excel or Microsoft Access, just to manage these data in table format. There's also optical character recognition tools, which can help you convert scanned documents into readable text. And for more complex and large-scale projects, we've seen experts use custom scripts to extract and clean the data and store all this data into what is called a relational database, where information can be queried and cross-referenced very efficiently during the drafting of their reports. So as you can see, technology has helped a lot with managing large volume of documents. However, as an automated process, it does not remove the data gaps or the factual inconsistency that often exist in disputed projects. And that's why the expert remains responsible for verifying project documents, understanding the gaps, and also being able to explain everything, especially when it comes to their key findings. Now we have the input information, we can move on to the second stage, which is the analysis stage, where all this information will be interpreted and analyzed by the expert. And this can be done by using a number of different simulation and modeling tools, depending on the discipline of the experts. In delay analysis, a very common tool that we use is the program, they are the planning and scheduling software. For example, Primavera P6 or Microsoft projects. These programs are usually created at the start of the project and managed by the project team. These are very useful to understand what was the planned sequence of work and how was that plan changed over time. These programs are sometimes used by experts to simulate different delay scenarios based on different delay events. Other than delay analysis, in disputes that involve engineering and coordination issue, we have also seen the use of finite element in modeling and building information modeling. This can help to simulate geotechnical behavior, structural behavior, clash detection, and coordination issues. So there can be many tools available, but there is a common risk among all of them, and that is because simulation always are reliant on the quality of the model itself. And furthermore, it's also depend on the assumption and the quality of the input that's used by experts. So even though there are many tools, we've normally seen experts trying to return to more simpler approach that is backed up by common sense and sensible judgment. After the analysis is done, we'll move on to the the delivery stage or the output stage, where the focus is about communication between the expert and the tribunal. So, because construction project is very technical, it highlights the importance of clear communication, and even the most robust analysis can sometimes carry little weight if it cannot be communicated clearly to the tribunal. And in this case, in the hearing, expert can always benefit from using clear presentation, graphics, or bar charts in order to help the tribunal to understand the technical aspect of the expert reasoning and calculation. There's just one thing to note is that even though this visual tool can be very helpful, there's always a balance between using these fancy pictures and fancy visualization and to still ensure that it's not distracting the audience from the main point. So that's basically the three main stages of expert work, along with the common tools that are used by experts nowadays. And that will bring us to the last section, which is about artificial intelligence, a very popular topic nowadays. So by definition, artificial intelligence is a broad field that refers to technology that designed to enable machines or computer systems to perform tasks typically associated with human intelligence. A very common misconception is that AI is something new. However, it has been existing in our life for a long time. And for example, there are transcription services, OCR, recommendation system, or data analytics. They are all AI technology. I think what has changed the most significantly recently is the capability in computing power and data. And that's why machine learning is now capable of recognizing patterns. And you see a lot of applications that are being able to generate new contents. And that's how the recent discussion come about, and technology, artificial intelligence now become more and more relevant in our practice, which also bring about a lot of concerns in relation to data protection, reliability, and also credibility. Recognizing both the benefits and the risk of AI, a lot of professional bodies have issued guidance to help practitioners navigate how to use the new technology. And today I want to introduce to you a framework by Academy of Experts, which is the guidance for expert witness on the use of artificial intelligence. And the highlight of this guidance is that it distinguishes between different levels of risk associated with the use of AI. So I think it's important to look at artificial intelligence as a spectrum rather than an all or nothing approach, right? So on the screen, I have put together a simple chart summarize different levels of risk of using AI, from low risk uses such as administrative tasks, such as summarizing documents or organization or just translation. Then we move on to medium risk group, which include research or plotting charts and analyze data. And the high risk use would include where AI contributes to analysis or reasoning of the experts. The key principle is that AI should be regarded as a tool rather than a replacement of expert judgment, and that any use of AI must be transparent and its output must be properly understood and explained by the expert. We've now come to the last slide, and there are three main takeaways. First is that experts are nowadays required to deal with increasingly intensive and complex project data. Technology plays an important role in helping experts in manage information, analyze information, and present information. However, it does not remove the responsibility of the expert. And looking ahead, there's emerging technology with potential like artificial intelligence. However, the adoption remains uncertain and likely to be gradual. So if you take a step back, technology has always been part of our life and been coexisting with our work for a number of years. But one thing that remains unchanged is that it has never removed our responsibility from our work and as well as human judgment. Ultimately, the quality of expert evidence depends not on the sophistication of the technology used, but on the expert ability to provide independent, well-reasoned, and an analysis that can withstand scrutiny. With that, I hope you help find this presentation useful in some ways. Thank you very much.
We have 20 minutes for question. So I think for the time being, I will give an eye-brushing question to Frederick, and later on I will give the Frederick and two other speakers to you to raise a question. So my first question is how can we select the right expert from beginning? Because sometimes the expert who will work as advocate rather than supporting tribunal. So Frederick, can I have your idea?
Usually experts have a reputation. So I think you want to have the right expert who has that reputation of not being the partisan expert. There's a lot of trust in, we've been using experts for a very long time. We've got our pool of experts and we've known them very well for a long time. But what we found is that those experts who tend to minimize, try to minimize the downside to their client's case are not the sort of expert we want to favor, because when it comes to cross-examination or witness conferencing, it will be very visible at the hearing. So you want someone who really is credible, someone who can actually at times concede points. And conceding points is not something which is embarrassing. It may be something that you've come across new documentations, or you've considered the other side's expert's case or arguments, and you actually recognize that, yes, I could have actually considered that argument or that set of data, and therefore I will do an alternative analysis. And that's absolutely fine. That's part of the expert's process. So really, it's, what you're looking for is someone who would be obviously assertive. That's important. Sometimes we see experts being quite aggressive. I think this aggressiveness is a sign of, weakness and insecurity. You want someone who will actually take the stand, confident in the analysis is carried out. There may be points you may want to consider even at the hearing, but with this sort of gravitas, he will be coming across as the credible expert that the tribunal will favor. I think the one thing we see a lot in construction arbitration when we have complicated delay analysis is the inability of a tribunal to tweak the analysis, or to say, actually, I favor neither of you. I found, you're good expert, credible. How do I found now to determine the extension of time? It would be, it require a lot of effort from the tribunal. And what I see sometimes is tribunals who actually just adopt one expert's analysis. And this is where it's becoming difficult because, you know, it's not black or white. There may be things that needs to be adapted to the experts' findings. And this is where I think, you know, the role of experts, possibly with the help of the tribunal post-hearing, being quite relevant.
Okay, so any question from the audience? Emma. When you raise a question, introduce about yourself and your company.
Thank you.
And
Thank you.
who do you want to ask?
Thank you. My name is Lynette from L&T Partners. I have a questions to the panel regarding the modeling and simulation vis-a-vis contemporaneous record. So I often see, very often, that in the request for arbitration, the claimant talk about delay for site possession and utility removal. And then in their experts report, they say the critical path is in design. So they quite contrary to what they submitted in the request for arbitration. In another case, the request for arbitration is talking about suspension on the main line. And then in the expert report, they're talking about the depot. So they are, maybe they are independent, but the problem with the experts is that they look at the Primavera and then they say, oh, this is the longest path, therefore it's critical. Whereas in the minutes of the meeting, people never talk about, for example, people never talk about the depot, they talk about the main line. And in the meeting, they never talk about, they did talk about the thing they mentioned in the request for arbitration, because that is the point that they argue the most of the time. But in the end, it turned out to be the tribunal is going to be decided on something people not even disputed, as a matter of fact. So what is that the problem, and how to solve that? That in the end, we trust the experts like we trust God. Yeah, we don't question them. That's the big problem. The other problem is that, like my colleague, Mr. Frederick Guillon said, we trust the expert because of their reputation. So the older they are, the more cases they represent, the more trustworthy. That's the mindset of the tribunal. So, and the more expensive they are, probably they are the more trustworthy they are. But we often forget that the older they are, the less time they have, and maybe they rely on their assistant. So when we're questioning them, hey, have you already considered this? Whether we consider that, and they probably say, yes, I did. It's all in the report. Where? You know, I don't have time now, but I did put it in, read it. So that is a quite embarrassing discussion between the lawyers and the experts. So what would be the solution for that? Thank you.
Thank you for the question, and also for raising a lot of issues that has been talked a lot about in expert work, especially when it comes to the use of the software that is, and then make the conclusion which is not close to what happened contemporaneously on the project. I think in one of the slides, I've talked about a lot of software, but our analysis has always been grounded by common sense and understanding of what actually happened on site. So I think it happens because when computer with program happens, we see that they have capability of simulations and scenarios analysis. So there has been a lot of use of those. However, in the end, it's still about factual. So it's still about the factual information that is the most reliable. So I think maybe Frederick or Leslie, you can add something on to that.
Yeah, I think, the fact that sometimes the analysis is not backed up by facts is, I think, the thing that we would say, well, clearly it's a sign that your analysis has something wrong, because if the people on site never raise this issue, it must be because the analysis is not done properly. So I think, tribunals tend to rely on what has been said contemporaneously during minister meetings. It may be that there may be other events that were not felt at the time being the critical events. And it's also the nature of when you make a claim, it's by nature prospective. So you don't quite know what's going to be the event or the effect of that particular event. So it may be, when you do the retrospective analysis, that the critical part was somewhere else. And that's absolutely fine. It can be explained, but at least the event or whatever thing that happened on site will be mentioned somewhere. But if there may be differences, and that's recognized by tribunal, when you do a prospective or retrospective analysis, there may be differences, but the underlying facts should not change.
Thank you, Dr. Lynette, for the very thought-provoking questions, as you often raise. And I think Frederick is right. We do have to reference back to the contemporaneous documents. I think where there appears to be gaps or difficulty in substantiating or holding up an expert's view, counsel's role really has to bring the tribunal back attention to what is supported by the facts and the contemporaneous documents.
So next question to Mr. Nassim.
Hi everyone, my name is Nassim. I'm a lecturer at Massey University in New Zealand. Yeah, I've got one question and a recommendation as sort of invited by the panelists. And the first question, the question is quite simple. The protocol is referred to as protocol for arbitration. Is there any particular reason for calling it arbitration? By the way, it's a brilliant initiative, and maybe the other SELs from around the world should also copy it. Apparently, there's no copyright or whatever. Just copy and refine it to suit. Now, so my question is, why do you just call it for arbitration? Is it because in Singapore, under the security of payment, you don't normally have experts? So that's a question. And then I myself make my comments first, because there's no need to respond to the comments. Now, I've looked at the protocol actually just this morning. And as I said, it's a brilliant document, at least there's guidance. But in terms of the drafting style, I've got a little bit of a feedback, a suggestion. The word shall is used 9 times. The word may is used 4 times. And then the word should is used 28 times. And the word, there are a few related words. May I suggest that the word shall, which appears 9 times, if it is consistently used in the same meaning, it's okay. But it is not. I've already done the breakdown of how many times and all. Some of it is redundant anyway. But in case, because I'm not a lawyer, you may want to seek advice from the Singapore parliamentary drafters, because they're brilliant. They don't use shall anymore. Alternatively, you may refer to Judge Lee's paper that is very comprehensive. He tells the whole story. Just read it and you'll know the answer anyway. But if you want some help, I'm happy to share with you the 9 and how you would actually reword it. Okay, I can just send it to you. I don't need to be paid. I'm not a lawyer. I'm happily working at the universities. If at all, like Gabriel Corr's acknowledgement, if you think my feedback is extensive enough, you may acknowledge, not for me, to keep my boss happy. Otherwise, I say, why are you doing all this seminar and all that? You should be drafting academic papers. Anyway, if you could respond to the arbitration.
Thank you, Mr. Nassim. You've can really experience and feel the enthusiasm you have for plain English. And I fully expected this response, and I invited you to attend our session. And thank you for your comments, which I will share with the council. As for the question as to why this protocol was proposed for arbitration, basically in the arbitral process, we have full party autonomy, and really it's for parties who have themselves the interest to have a very efficient, effective dispute resolution process, to meet together, to streamline expert issues, technical issues to be addressed. So we do not impose ourselves on what we think the court process. Of course, in the litigation process, the courts do have their own prerogative to organize and direct the process in their own manner. And this really is to, the protocol is really to address the needs of stakeholders in the arbitral community facing construction dispute issues.
And not adjudication.
Not
That's my
adjudication, not adjudication.
Because you don't normally have experts in adjudication, is that?
Not typically.
Okay. Can it be extended to adjudication?
Not unlikely in the Singapore landscape, because loss and expense issues we typically do not address in the adjudication landscape.
Okay, next question can you go to Mr.
Good morning. My name is Harjeet Jaggi. I am from India. I am working as an arbitrator and a dispute resolution specialist. My first question is to Ms. Leslie Tan. Before this protocol came, and it has come very recently, just 2-3 months back. So were there any specialized problem? Were there any particular problems in the gathering the expert evidence, which probably led to this protocol? That's one. Then question to Ms. Nguyen Chang. This AI tools, are they specialized for expert evidence, or they are, they have wider applications and can also be used in the for the expert evidence? Thank you.
Thank you for the questions. For the protocol, it was developed not so much to address issues with gathering expert evidence, but really in the sense of having the experts' report be aligned in a way that is helpful to the arbitral process and addresses the questions that the tribunal wants addressed. I think that is the key issue that the protocol tries to address.
Yeah, for your second question, the guidance from the Academy of Experts is for both the commonly basic tools that you see available on the market and also the in-house developed tool for expert work. As you can already know, a lot of firms now are looking at AI initiatives. So definitely that's the next development. Yeah.
Thank you.
So we have time for the last question. Can you give microphone to the lady in the corner?
Thank you, the panel. It is Minh Nguyễn from ACSB Legal. I have a question and would invite the perspective from both quantum expert firm and law firm. So as you can see in the expert witness problem, sometimes like the claimant will need to pay like $50,000 or even like $100,000 to their own expert witness, and then the respondent the same situation, and because of the all the way problem in the expert testimony is that as I think Leslie or Chang said, is the unconscious or conscious partisanship, the feeling of loyalty towards the party appoint that expert. So eventually the tribunal would also recruit their own experts. So So the overall circumstance is that the whole the whole cruise of the dispute paid, let's say, like $300,000 just to find out what is the factual information. So do you think that that should be the future of the expert witness industry, that instead of paying for a human, then the expert firm or law firm, for example, should develop their own, like AI or an app, a program, which let's say like Gemini or ChatGPT, for example, and you can train it. But then that, because that is the AI, right? So you don't believe that they will have the unconscious or conscious loyalty toward the party appoint that AI. So in such a case, perhaps it is more cost efficient for everyone to just like use AI as the witness, as the testifying witness. So first of all, do you think that is the future of the expert witness industry? And second, in case both parties agree to appoint AI to be the expert witness, do you think the tribunal should agree on that solution?
There are different layers to your question. I like the first part about having the tribunal appointed expert, which can be something else than AI. It could be actually proper expert, human being. It's something that is not commonly used in construction arbitration. But it's not to say that it's not going to be used more. And certainly it's not the future. It's actually currently what is being used in most civil law countries, where typically for court proceedings, you would have involving, construction issues, you would have an expert being appointed by the court, and then each party would have their own expert. But certainly the process is driven by the court-appointed expert. So that's not the future. It's not the future, or it's not something that you see in common law jurisdiction, but certainly is the rule in civil law jurisdictions. To what extent this is efficient? The way it's currently used in most civil law jurisdictions is truly inefficient, because the experts proceedings tends to last for 2, 3, 4, 5 years sometimes. So I think it's a good idea to bring that together, in this one set of proceedings. But I don't think it's a bad idea. In fact, I don't know if you know Doug Jones, reputable construction arbitrator, is very much in favor of having a court-appointed, well, tribunal-appointed expert, which obviously adds to the cost, but actually may play a big part in having a probably better decision for less experienced arbitrators in construction disputes. So I leave friends to talk about AI and whether we could have an AI expert.
Yeah, thank you for raising a question that is very difficult to answer. So it's about whether AI is gonna replace our role as expert. I think the same question can be asked as to whether AI can be replacing arbitrators, because your concern is about biases and duty to the party. But the duty of expert has always been to assist the tribunal, and I don't think that's gonna change. So to answer your question, in order to have an AI tool that can replace expert, I don't think it's gonna be anytime soon, because we will require a lot of data to be able to train that model in order to get the same number of years of experience to be able to understand the project and make the judgment call and ask the right question. So, like technology has always been there, but there's always the role of engineer, professional engineer, expert, someone to be held responsible for something. So I think somehow technology, the change repeats itself, but only this time is more drastic. And what we need to do is we need to raise the ceiling for our quality of work. Having a team of expert with a depth of experience that can troubleshoot the issues, that can ask the question, and that can still remain independent. Yeah, that's.
I would just share that in my arbitration processes, on a number of occasions, I've had the tribunal suggest to parties, which parties then took up the idea of appointing a joint independent QS. And I think for quantum matters in particular, it's very useful. And I think the tribunal sometimes want to park like maybe the 500 disputes over variation orders to be addressed by an expert quantity surveyor to make decisions on quantum issues. And I think when it's parceled out into that particular topic, can be more cost efficient than for the tribunal to address all these issues on top of other legal questions and delay issues. On AI, I think the challenge will be that for an AI system that applies to all parties, I mean, where dispute resolution is inherently an adversarial process, and I think for parties to try to agree the same platform and making it available and on a cost sharing basis, that's something to observe, but it may take a while. At least for counsel, I think because confidentiality is of the utmost importance, we would tend to generally refer to our own internal AI platforms from which we can secure confidentiality, secured server access, etc. So if it were a common platform, I think those issues would be even more elevated and challenging to address.
What you do see in some pilot schemes in courts for smaller disputes, basically the court deciding for a particular threshold, it will be decided by, against pilot scheme, by a machine to see what the result, based on current case law, and it's surprisingly, or unsurprisingly, extremely efficient, and you achieve obviously justice very quickly, which is sometimes the ultimate purpose of that.
Okay, thank you. Our time is over, so we should take a short break time now. Thank you for your time. Yeah.
You making your presentation in French or so you are able to follow which are your with the vehicles. Actually, yeah, based on such stuff. Hi.
May I invite our distinguished speaker, Mr. Ho Chien Mien, Mr. Lê Minh Sáng, and Mr. Hajat Kumar Jagi to the stage, please. Ladies and gentlemen, thank you for joining us today. Our session will start now. The focus of our session is on the topic regional topical issues. Before we start, I would like to introduce to you our panel, which includes three distinguished speakers and me as the moderator. So by way of introduction, I am Minh Nguyễn from HICAC Legal, and I am very honored to moderate this session today. So this session will take place in 1 hour and 30 minutes. And if the time allow, then if we receive less questions from the audience, then we might be able to end this sooner, so everyone can head to the lunch. So the panel today include 3 speakers, Mr. Ho Chien Mien, Mr. Lê Minh Sáng, and Dr. Hajat Kumar Jagi. So first of all, I would like to introduce Mr. Ho Chien Mien to present his topic. Mr. Ho Chien Mien is currently the partner of Ireland and Gladhill. He is co-head of the Ireland and Gladhill's construction and engineering practice, and undertake a wide range of contentious and non-contentious construction and engineering work in Singapore, Asia Pacific, and the Middle East. Mr. Ho Chien Mien is a senior accredited specialist in building and construction law. He is also ranked in the top tier of chambers and partners and the Legal 500, and identified as a thought leader in construction law by Who's Who Legal. Mr. Ho Chien Mien, please go to the stage. Thank you.
Thank you, Min. Morning, everyone. Today I'm talking about topical issues in construction arbitration. I think for most of you who have been here over the past day or so, you have heard actually quite a lot, on this. But because of time constraints, I think most of the speakers have been going through some of these issues rather quickly. So what I intend to do, instead of just taking you briefly through some of these issues, perhaps I can just concentrate on 2, perhaps 3 issues. I think they are quite interesting. But first of all, just a quick introduction to the scale of construction disputes are being handled around the region. Just a quick reference to the VIAC statistics. From what I can find, this is 2023, so it's not exactly the latest. But as you can see, in 2023, there's 424 cases. There's 46% increase year on year, and 19% of those are actually construction disputes. And the foreign parties comprise 2/3 of the foreign parties involved are from China, Korea, and Japan. In contrast, where I can get more, or rather more recent information, this is from 2025. There were 886 cases in 2025. That's a record. 9% of those are construction. So it's actually a lot less than Vietnam. But a lot of these cases are actually very high value disputes. And top users, interestingly enough, one of the top 3 users is actually Vietnam. Okay, so these are the typical issues that you find in a construction dispute. I think all of them, all of you should be quite aware of them. Whether or not your claim is 500 million or 5 million, these are the kind of claims that will come out most of the time. The only difference I would see between a $5 million claim and $500 million claim is essentially the $500 million claim usually is much larger and a lot more complex. There will be a lot more technical and engineering issues involved. Now, I'll talk through most of them. The last one, dispute resolution arbitration within the VIAC framework. I was going to talk a bit about that, but having heard some of the Vietnamese lawyers and policymakers talk about this, I think I'll defer to them. They obviously know this a lot better than I do. Okay, let me start with delay claims. So now, delay claims are very interesting. It's actually when you deal with delay claims, there are two types of issues. You can sort of categorize them into two main issues. One is a legal issue. The other one, is a technical issue, right? Most of the matters have a mixture of both, but essentially they can be categorized as such. Legal issues, I'll deal with them in a bit more detail, like now. Sorry. Okay, so these are essentially the legal issues. Party that causes the delays, that's one of the issues. On the face of it, it seems quite simple and straightforward. It's a factual issue. Who is the party that causes the delays? But it's not always the case, as I will explain in a short while. This issue of delay also has a lot to do, most of the disputes have a lot to do with neutral events. Because when you're talking about delay caused clearly by one of the parties, the employer issuing variation works, the employer giving late site possession and things like that, it's quite clear who is the party causing the delays. Or from the contractor's point of view, if the contractor has a labor resource issue and all that and couldn't proceed in accordance with the program, it's quite clear who causes the delays. So this is a fact and a finding issue. However, the identification of the party that causes the delays sometimes, especially with so-called neutral events, are not that straightforward. Let me just give you an example. We are doing a very big case at this point in time involving a public infrastructure works in the Middle East. It's an arbitration, so I can't mention the parties. But in this particular case, there were a lot of delays caused by delayed regulatory approval. Okay, as you can see, this is the same thing that will occur in a lot of public infrastructure projects. Whether or not you're talking about Singapore, we are talking about Malaysia, Indonesia, all the way up to Middle East or even Europe. It's the same. Now, why do I say that this could be a problem sometimes? In this particular case, the client, which our contractor, my client's contractor, but the employer in this particular case is a government entity. Okay, it's the public works department of that country. Now, a lot of the delays were caused by delayed approval of regulatory authorities by another branch of the government. In this case, the building construction authority of that particular government. Now, you would have thought that you have to look at the contract to see who is responsible for delays caused by regulatory approval. And sometimes it is specified in the contract. But when it is not specified in the contract, who is to take that risk? Sometimes this issue arises. In fact, even if it is specified in the contract, you can still argue quite a few things. In this particular case, the Minister of Finance, by virtue of his role, sits on the board of both the Public Works Department and also the regulatory authority, which actually approves all these applications. So the question now is that are these two different entities altogether? Okay, or do you consider them as one party, right? Such that the delayed approval by the authority can be considered a delayed approval by the government, and therefore, the public works in the department of that government cannot say that I'm not at fault. You are supposed to take all these risks associated with delays, because the delay is from another branch of the government. So it's not that straightforward, especially as I say, public infrastructure projects, and this is something that is being arbitrated at this point in time. Okay, so these kind of issues can arise. So there are other issues, legal issues such as notices, scope, and requirements. Sometimes it is quite clear who is responsible, for the delay. But the question, is not just who's causing the delay, but did you comply with the contractual requirements to claim, for the extension of time for all the extra costs which has arisen? Have you met the contractual requirements to give notice? What kind of notice you have to give? What is it that you have to give together with the notice? And did you give the notice within time? Okay, so have you met the condition precedent, in other words? So again, you have to be very, very careful. Just because it is very clear who is entitled or who is caused the delay doesn't mean therefore that you are 100% or guaranteed to to be entitled an extension of time. You still have to comply with the contractual requirements for doing so. Now, allied, with this issue of a condition precedent, as with all the cases that we'll see, there are always cases of waiver and estoppel. Okay, some party will argue that while you may be entitled to an extension of time, but you failed to put in your notice in time, or your notice doesn't comply, right? And the other side will say, well, actually, I wanted to put in the notice, but at that particular point in time, one of your guys, the project director, told me that don't worry too much about all these notices. We will discuss all this at the end of the project. Sometimes it's not even that clear. You just say that, look, just put all this to one side. Okay, just get on with the work first. So the question that often arises in that kind of scenario is this a waiver? Okay, have you waived all these condition precedents which are required in the contract, right? Okay, and then other issues that will arise: concurrency and causation. These are mostly technical issues. Causation is like, just because there's a delay in, let's say, issue a particular approval for one part of the works, does that mean therefore that it has a critical impact on the works? That means, would it actually delay the completion of the project? So that requires a critical path analysis. And you have this issue of concurrency as well. Concurrency is not that simple. Just because there are two delays occurring at the same time, one by the employer, one by the contractor, doesn't mean therefore that there's a concurrency. Because what experts are always trying to find is there a true concurrency in this particular case? And if there's a true concurrency, what is the legal consequence of that? You see in a lot of the well-drafted contracts, especially if you're working for the employer will say, in the event of any concurrency, the contractor is not entitled to any extension of time or any cost. Okay, so that is quite clearly provided. So in that kind of scenario, the contractor will have no claim, even if one of the concurrent events of delay is actually caused by the employer. LDs, very, very interesting topic. Very interesting because in Vietnam, originally Vietnam, as I understand it, has this idea that you cannot claim for LDs. You can only claim for actual losses. So there's no concept of pre-estimated damages. Okay, but the strange thing, well, at least I find it strange, is that you can actually claim penalties. If you state in a Vietnamese construction contract that if you don't complete this job by a particular date, you have to pay a penalty of how much, that is a clause that can be upheld, right? Under Vietnamese law, at least. So that is the complete opposite of common law. At this point in time, as I understand it, Vietnamese law has been changed or will be changed shortly to bring it more in line with international practice. Now, LDs are actually quite interesting because LDs, liquidated damages, for those of you who are not familiar with it, is this concept that you will, at some point in time, when you're signing the contract, you try to estimate ahead of time what are the likely losses that you will suffer if there's a breach of the contract. So, for example, a delay by the contractor is a breach of the contract. If there's a breach, then what are the losses that you will suffer? Now, if you think about it, okay, this concept of pre-estimating the damages, and it must be a genuine pre-estimate, is actually not that simple. For a commercial project, it may be a bit more straightforward. You are building, let's say, an office building or hotel, okay, you don't complete in time. What you suffer essentially is the loss of rental or the loss of the revenue that you can collect from renting out these rooms. So that's quite straightforward. But for a public infrastructure project, that is actually very, very difficult, right? Because if you think about it, okay, at some level, yes, you can estimate the level of losses. If you're building, let's say, a railway, you're building, let's say, a road, you can say that, well, you can calculate the losses by the loss of revenue, the toll that you're supposed to collect from the road users, the railway tickets that you could have sold. Those on the face of it, okay, could be your losses. If you're building the airport, the landing fees, okay, whatever fees that the passengers pay, all these you can calculate. But in reality, some of these losses are far more than all this that you have suffered. Because if you're talking about major infrastructure project, the loss to the government, okay, the loss to the state as a whole is actually usually far, far larger. Okay, it's calculated in terms of percentage of the GDP rather than just this $1 million a day or whatever it is, right? So if you're talking about a big airport project, you have a dilemma there because you can calculate roughly how much you lose, from, let's say, like I said, landing fees and things like that. But the real loss to the state is actually a lot larger. The question now is, how do you even pitch the LD figure? Because if you pitch the LD figure at such a high figure, one, nobody will want to bid for a project. Secondly, even if they want to bid for it, you get a ridiculously high price, right? But the problem is that if you pitch it too low, at least from the Vietnamese perspective, there could be an issue, because as I understand it, you got to show that the pre-estimated damages must correspond to whatever breaches, correct? So in a sense, if you think about it, for a big public infrastructure project, let's say the high-speed railway between Hanoi and Saigon, right? So the question is, if you pitch it too low, then does it correspond to the breach? And if it doesn't correspond to the breach, then is that LD provision invalid, right? So these are the things that you need to think about when it comes to LDs, especially in the Vietnamese context. Okay, let me see how much time I have. Okay, I have about 3 minutes. Let me talk about force majeure, which is the other thing which is quite interesting. Because it's something, again, the Vietnamese government is trying to bring this concept more in line with international practice. Strangely enough, in international practice, especially if you're under common law, not civil law, there's actually no concept of force majeure as such. So therefore, if you sign a contract, and the contract doesn't contain anything referring to a force majeure risk, the problem is that what you might consider a force majeure risk, or what some people might think is as an act of God, the common law doesn't deal with that, right? So if that risk eventuates, the usual rule under common law is that the contractor takes any risk, okay, which is not specifically allocated to the employer, because the contractor has the obligation to complete the project within time and within whatever price that's been agreed, okay? But if you see most of the contracts, FIDIC, whatever it is that you use as standard forms, all of them would provide for some form of definition of force majeure. So force majeure is exactly what you define it to be, right? It's not actually a sort of the concept that's explained in the cases that you can refer to. You can define whatever you want to be a force majeure, right? And when a force majeure event happens, the contract also prescribes what is to happen in the event you can show, or the contractor can show, that there's a force majeure event, because the contract can say is that in a force majeure event, which is usually a neutral event, okay, as opposed to employer caused delays or contractor caused delays. A neutral event, war, insurrection, epidemics, nothing which is the fault of the employer or the contractor. In this kind of case, the contract can prescribe how the risk is to be shared. It can say that, look, contractor, you get an extension of time, but you get no cost, right? So the employer takes the risk of delayed project, but the contractor takes the risk of increase in the cost. And you can allocate it whatever way you want. You can say that you can get half the time and half the cost. That is entirely possible, as well, right? So it's up to you how you want to allocate in such risk. Do I have time? Okay, I have 1 minute. Okay, just a very quick one on this force majeure event. It's quite interesting because I recently have a big project which we are dealing with. There was a 300 days delay due to delay the site in the possession. Okay, so there's a loss and expense clause in the contract that allows the contractor for claiming loss and expense. Loss and expense would mean idle labor, your rental of equipment and all that, all these things which you are paid for already sitting there, you cannot use. But the question then is, Then the Iran war happened. As a result of the Iran war happening, diesel prices went up the roof. Okay, prices of material, aluminum, steel, and all that went up significantly as well. So the contractor is saying to me, look, it's very unfair on me because I'm delayed on site for 300 days. I could have gone forward in this project. I could have ordered everything right at the start. I wouldn't have had to deal with all these increased costs. Right? So if you were just to allow me to claim loss and expense based on idle labor, rental equipment, all that, it doesn't cover any of my costs. My real cost, okay, is the cost of all these increase in materials, increase fuel prices and all that. So you have to think in this kind of scenario, would the force majeure clause help? If not, would the loss and expense clause actually help you recover those kind of loss in addition to the usual, like I said, idle labor and rental equipment costs. Okay, so I think I should end off here. Otherwise, my fellow speakers won't have much time to talk. There will be a question and answer session later on. I'll be quite happy to take questions later on. Thank you very much.
Thank you, Mr. Ho Chi Minh. Yes, so we will reserve about 30 minutes for Q&A session. So if you have any question for Mr. Ho Chi Minh, please write down, and you can bring up the question when we go to the Q&A session. So moving from the topic that Mr. Ho Chi Minh presented about liquidated damage and causation, we will go to some procedural issue, and I would like to invite Mr. Lê Minh Sáng to deliver his speech. The topic of Mr. Lê Minh Sáng presentation focused on parallel proceeding and multi-contract, multi-parties issues. I would like to introduce a little bit about Mr. Lê Minh Sáng background. He is a PhD candidate at University Lumière Lyon 2 in France. His doctoral research focused on arbitration and merger and acquisition dispute. He holds 2 LLM degree from France, one in international business law and one in European law. Mr. Lê Minh Sáng is also an active member of Hong Kong International Arbitration Center, the Society of Construction Law Vietnam, and currently serves as the reviewer for the European Journal of Legal Studies. So with his intensive academic background, we would love to hear from him. The stage is yours, Mr. Sáng.
Hello everyone. I'm Minh Sáng. Today I really honored to be in front of all of you to present my paper regarding a very topical topic concerning, because when I'm doing my PhD research in arbitration and in merger and acquisition, I found out this matter, like I can see the similarity between merger and acquisition and construction. So that's why my title can be like kind of multi-party and multi-contract, lead to the parallel proceeding and some insight for Vietnam. So my presentation will include 4 parts. A little bit about multi-party and multi-contract in construction arbitration, parallel proceeding in construction arbitration, and finally I try to find out some key techniques, also insights for Vietnam's context. Okay, so the first one, because I just only have 15 minutes, so I don't want to go this part further, because everyone knows like the importance of the industry sector. So you can see some figures under the Vietnam context. Okay. So the characteristics of the dispute in construction project kind of complex, high risk. Everyone know about this. So the dispute consequences, you can see this, right? And why arbitration is preferred in the construction dispute? You can see some key reasons. The first one you can see the procedure, the procedural flexibility, because it's agreed by the party agreement. So it's kind of the private forum. You can describe that's the kind of the private dispute resolution designed by the parties. So it's kind of a contractual relationship and give the power to the arbitral tribunal. So the first one, the third one, really important, because you don't need to go for kind of the national court, very tradition in the specific nation, something like that. But you can go for any arbitration center, and you can get it enforced and recognized in the tradition you want to it enforced or recognized. So the last one, very topical in the construction sector, because the parties in the construction sector really need the confidentiality in disputes, because many consequences if the information leak during the dispute process. So the third part of my topics go straight to the issues regarding multi-contract and multi-party in construction arbitration. Why? In terms of multi-contract in construction, because construction sector involve the many parties. You can see including the project owner, kind of employer, main contractor, or subcontractors, designer, engineers, consultant, financial institution, and even suppliers. So it's create like a kind of multi-party relationship in the construction sector. You can see the an instance kind of regarding the FIDIC. You can see Red Book, employer design, yellow book regarding design build, silver book, EBC turnkey, something like that. It's create the second issues regarding the multi-contract. So under Vietnamese law, Article 82, you can see a list of the types of the construction contracts. It's kind of based on the FIDIS contracts, so it's trying to follow the FIDIS standard. So you can see the multi-contract involved. Okay, so for example, very important now, because it's really hot topic now, because you can see super project in Vietnam now called the long-term international airport. You can see the many parties and multi-parties involved: project owner, contractor, architectural design, design and engineering consultant, operation, something like that. So between all of the parties here, so they have like separate contractual relationship, like the contract between them. So the second part helps you know about like a multi-contract and multi-party, so you can see how it's influenced, like a construction arbitration, and that's the reason leads to the parallel proceeding. very academic because according to the professor, very prominent in arbitration proceedings in international arbitration refer to the situation in which two or more dispute resolution proceeding are conducted before the different adjudicatory parties, at least one of the which is an international arbitral tribunal, because it can be different with like a parallel proceeding in the court, because kind of like, you know, the address, there's one of which is an international arbitral tribunal. Okay, so how to identify, you know, like the test to qualify parallel proceeding. The first one, that's it, the same parties, because when a forum consider is kind of the parallel proceeding, you should take this test, this triple test. The first one, the same parties. The second one, the legal and the factual basis of the claim, and the last one, the kind of regarding the relief or remedy sought. If the same, if all of them the same, we can call it a parallel proceeding. So why they occurs in construction arbitration? I already let you know about the multi-contract and the multi-party in construction status. So why? So why it can be influenced into construction arbitration and parallel proceeding in this setup? The first one, the multi-contract with different dispute clauses. You already see this, the separate arbitration agreement, because multi-party, multi-contract, they have like, you know, like a spirit story between them. So some parties in this contract and another contract in the construction, even though they have like, you know, like contractual relationship, but you know that they don't want to go for this forum or another for them, because they don't want to consolidate the the arbitral proceeding, because they have a different benefit from, you know, like, because some contractual relationship with another party, with a different party, they want to chase their own benefit. So that's why they create the fragmented dispute resolution. Okay, so you can see the vertical and horizontal contractual structure and contractual chain between. You can see the relationship between them. Okay. So the risk, you can see everyone know about the risk parallel proceeding, increased time cost, procedural inefficiency, conflict judgment to arbitral award, and difficulty in enforcement, because it can be the different decision in the different forum. So what is the best way and some legal insight for resolving this matter? Okay, because I'm really academic guy, so because find out academics doctrines really important, because you can we can know how the law can be understood and applied correctly. So the first one, this respondent, like, meaning a lawsuit pending always require the forum say later to stay a decline jurisdiction if another adjudicatory party already been say of the same dispute is kind of at the stake of the acceptance of the proceeding the case. The second doctrine regarding the res judicata is kind of a problem solved. So you cannot go for another forum to re-litigate the dispute. So you pose 1 and 2, another manifestation of the principle of the ne bis in idem is kind of a Latin doctrine, not twice for the same matter. So, but just different the the periods of time. The first one for the times of acceptance of the proceed the due, after proceed the dispute. But the second one, when the decision rendered by the forum dispute resolution. So in addition, one doctrine called competent kind of the arbitral tribunal has the authority to determine its own jurisdiction, because this can be a doctrine, but it cannot solve completely the problem regarding the parallel proceeding, because another party also can have a possibility to go for another forum to resolving their dispute and concerns. Okay, so how the legal provision under Vietnamese law like kind of legalize those doctrines. The first one, article 4 and 71 of the Civil Procedural Code. So you can see regarding the respondent trying to decline the claim before another court if it's already accepted by the one court in Vietnam. So under commercial arbitration, Article 6 of the law on the commercial arbitration, the kind of regarding the arbitration where the parties have concluded an arbitration agreement, of course, must refuse to accept the case if one party initiate the court proceeding unless the arbitration agreement is invalid or incapable of being performed. This also apply for another arbitration forum, because it's based on the arbitration agreement. So if parties agree for specific arbitration, another arbitration also cannot, except for the resolving the dispute, agree party for another arbitration. So the second one, regarding the res judicata, the legal provision under Vietnamese law say the same. They trying to refuse the claim of the parties already in which the decision of the court already rendered. So you cannot go for another forum to re-litigate with another proceeding. So you can say that. So the last one, article for Article 4.3 of the law on commercial arbitration regarding the competent dispute. So you can use this mechanism to try to determine there's all jurisdiction to handle the case. So another forum cannot accept the file for resolving after their benefit into their dispute they want to do. Okay. So what's the solution for this matter? I found out kind of the three techniques, also the kind of pay-ons like legal tools under the law and arbitral institution rules. Consideration, the first one, of the related arbitration and the trial for the third party, because we got the two problem, the multi-party and multi-contract. The multi-party regarding the consolidation, they want to consolidate the arbitral proceeding into the one, but it's also required maybe, I think, in the three situation. The first one is required party agree to consolidate, but the agree here is not really explicit, because it's the consent in writing or not, or just implied consent. That's also the problem, because some arbitral institution rules requires the consent here must be in writing, but another very flexible to allow the parties because the parties autonomy because they're not required this consent in writing. It's just like prima facie. It's kind of okay. You just express a little bit about that. So okay, arbitral tribunal can accept that's a consent between the parties. The second criteria, it can be like kind of the same arbitration agreement. So that's it, one of the condition to let a parallel proceeding consolidate. But in case if because multi-party multi-contracts, I don't think I don't think most of them will be in the arbitration, in the same arbitration agreement. So the third criteria, because I just refer to the ICC rules and LCIA's rules. So the kind of the ideas from them. The third one, if they're not in the same arbitration agreement, maybe they just need like like close legal relationship, close legal construction, legal contractual relationship, and just arbitration with kind of the compatible. It's not required to be the same in arbitration agreement. Is kind of just compatible and they have a very close legal contractual relationship. So that's in that matter you can they can be consolidated the arbitral proceeding. So the second one, the kind of the techniques, the facilitating the appointment of the same arbitrator in related proceeding. That's also the problem. But I hope you can ask me this matter because if in case in the assumption two case different, but different appointment in arbitrators is also the problem in consolidation of the arbitral proceedings into one. Okay, the last one regarding the seeking anti-suit and anti-arbitration injunction is kind of interim measure, but under Vietnamese law, it's not stated in this matter because it's also the problem enforcement of the interim measure. So, but under Vietnamese law now, there has been no provision for this matter. I remember in UK really famous for this tool. So that's the three ideas and insight for solving parallel proceeding in constitution arbitration because of the multi-party contracts course. Thank you so much for listening. So any question and concern? Hope to hear from you. Yes.
Thank you, Mr. Lê Minh Sáng. And next, I would like to invite Dr. Hazet Kumar Zagi to take the stage. Dr. Hazet Kumar Zagi has the Bachelor of Science Engineering from the University of Delhi and the PG diploma in public policy for Indian Institute of Public Administration. With more than 37 years of working experience, he is a notable figure in the role of independent consultant, arbitrator, and dispute resolution expert. And he frequently advise the party or delivers the opinion on the issue of FIDIC contract, EPC condition, EOT, and financial claim delay analysis. Dr. Has that the state is just? Thank you.
Good afternoon, everybody. The topic of my presentation is interest on arbitration awards. In many of the public contracts in India, in the standard conditions, the interest on any delayed payments, including the arbitration awards, is barred. That is as a part of the agreement. So we as arbitrators, we find it very difficult in situations where the delay was basically caused by the public body, and the matter, when it comes to us, some 5, 7, 10 years have already passed, and the value of the money which is due to the claimant has reduced considerably, but is nothing much which the arbitrators can do. Now I'll go into the basically, that's the arbitration is for expeditious and efficient justice, but then because of the delays, the time value of the money actually goes down drastically. Interest is the only way to compensate for that, and that, to my mind, it's central to the commercial justice. But the problem is that many of the contracts has this interest, this clause. It is worded differently, but that's the core emphasis. No interest shall be payable in any amount due. And this is also valid for arbitral awards. Actually, it is coming out of the Arbitration Act of India. The Arbitration Act of India actually has these two clauses. One deals with the pre-award interest on the award, and the other part of this clause deals with post-award. Now, pre-award interest, now in the 1996 version of the Arbitration Act, the distinction between the pre-reference and pendentality interest has been removed. Now, pre-award interest is basically pre-award, which includes both these periods. So this is discretionary. This is basically between the parties to agree or not to agree on this. Whereas the post-award interest is generally statutory. It basically lays down that by statute that the post-award interest has to be given. So this is discretionary, and this is statutory part. So this is how it is worded. The Act, the particular section of the Act says, unless otherwise agreed by the parties. So that means if the parties don't agree to award any pre-interest award, then even the Act doesn't come into the way. You see the other part, which now deals with the post-award amount of the award. So it says sum directed to be paid by an arbiter award shall. So this is where shall becomes, Mr. Amir is not there. So there is where shall becomes very important. So it shall carry an interest. Even the amount is fixed from the date of award to the date of payment. So that's the strength where the contract draws its power from. Now, the Indian jurisprudence in this matter has actually upheld the clauses. The clauses barring interest have been upheld by many of the courts in the past judgments. Even the most recent ones have gone by the contract. So what it says, in essence, all the judgments in the past, arbitrator is the creature of the contract, so the arbitrator cannot deviate from the contract. The contract clause which holds a bar on interest shall always hold. We cannot even use the term uses the generalities, which basically, some arbitral tribunal took refuge under this, that this is the clause started with security depositors. So they said that using this principle, doctrine, this applies, the interest also applies on the deposits or the retention money, but the courts have actually gone against those awards, and they have actually set the awards aside. Some of the courts judgments have also said that the tribunals cannot award interest even as a compensation of the delay in payment. And subsequently, the courts cannot modify or add any interest terms in the contract subsequently. Even the courts cannot do it. Because some of the lower courts, when they upheld the award, the arbitral award, granting interest was actually turned down by the higher courts. The only saving grace which the Indian courts have given to the arbitral awards is that if the terms of the contract clause are not very clear, then tribunal can take a view. So unless there is an explicit bar in the clause, the tribunal can take a different view. But generally, in the public contracts, clauses are very, very clear, and they are standard clauses, so nothing much can be done. Yeah, there are some clauses where they say that interest on delayed payment is not payable, but that is not payable by the engineer. The tribunal can take a view. So if it says just delayed payments, then the tribunal can have a different view. But generally, the delayed payments also includes, it's clearly stipulated in the clause, including arbitral award. So there is not much scope in the clauses also. They don't give the arbitral much scope. Now, what is the problem in this? Why sometimes we are inclined to compensate the claimant on this issue is because of these three issues. If the delays are anything varying from a year or 2 years to 10 years or even more, the value of the money, which may be $100 in 2010, is almost 1/4 in value today. So inflationary erosion. And this, there is actually an unfair advantage to the respondent, which is the public department. It retains that money interest-free. So this creates an unjust enrichment of one party at the cost of the other. And it incentivizes the other party in delaying the whole thing. There are 2-3 examples I have given. Now this is case 1, without naming the parties, without naming the case. Original completion was 16 months. After 31 months, the work didn't complete in 31 months. The contract was closed for want of land. The tribunal was appointed in February 2021. I was one of the members of the tribunal. 19 years later, the case comes to us. Of course, we take 1.5 years, close the case, give the award. But because of fear of the award getting aside, we did not award any interest for this 19 years delay. There's another case. I was the sole arbitrator here. Original completion, 8 months. The work could not be processed. Work could not even start. The land was available, but it was not unencumbered land. So contract was closed after 3 years. But the case came to me in April 2023, 9 years later. I couldn't give anything as far as the interest is concerned. There's another case. This is a very bad case. The original, no, this was not non-availability of land. This was a case where some wrongful recoveries were made by the public body. The claimant invoked the arbitration clause in 1994. The tribunal was appointed 10 years later. But for 15 years, the tribunal did not do anything. Or they did something, but they did not close the case. It came to me, again, I was the sole arbitrator in September 2019. And of course, in 6 months, I closed the case. The point is that, see, 27 years, the party has waited for justice. So basically, the issue is what we can do to, in such situations, to give some justice or equitable compensation to the parties. And this is important. This without violating express contractual provision on interest, because as an arbitrator, I would not want my award to be set aside. And as I have already told, that Indian courts have already held that the tribunal cannot circumvent contract by awarding interest in the disguise, format of damages, because of the risk of patent, the award getting set aside due to 2 reasons: patent illegality and excess of jurisdiction. So what do we do? So as a member of the tribunal, or as a single party tribunal myself, we try to see that if the interest clause is unambiguous, it bars the award money from the interest, then we can't do much. But wherever there is a possibility of interpreting it in a different manner, and for the purpose of exclusion of award money, then we try to consider interest. So what else we can do? Maybe compensate for the escalation, for the delayed payments. Give the party prolongation costs if they have asked for it. Consider their claims on loss of profit or opportunity costs. We have done it in few cases. And maybe I will give them the costs on legal and institutional and things like that. So before I close, I have few recommendations. I think there is a need to amend the Act, the relevant clause in the Act, to allow tribunals to give some leeway, some flexibility in awarding the interest. At least the Indian courts can, introduce a clause of unjust enrichment of one party at the cost of the other. So instead of saying no interest shall be payable, we should say no interest shall be payable except in case of wrongful withholding or, adjudicated liability. Thank you for your kind attention. If there are any questions, I'll be ready to take. Thank you so much.
Thank you, Dr. Hazet. May I ask some of the technicians to have to make the roundtable discussion in the state, please. Nhờ các em có thể kê bàn với chị đúng không? Yeah.
Let's just move to the
Yes, yes. Yes, so thank you very much for staying with us until this late lunchtime. Without further ado, I would like to invite the question from all the audience. In case you don't have the question, then I will raise some question for our speakers. So, is there any participant want to raise the question to any particular speaker, please? Okay. Yeah. So I don't see any hand raised. So I would take this unique opportunity to explore my curiosity then. So I have the first question for Mr. Ho Chin Mian, and this question is really relevant to our circumstance today. And actually, like you are handling this issue day by day this time. So in the context of the Middle East war at the present, how to prove the causal link between oil and gasoline price increase with a non-performance or delay in performance of contracts in construction sector?
Thank you very much for that question. I think, in terms of proving the causal link between the war and the rise in the gas and also diesel prices, to me, I think that's fairly obvious. To a certain extent, it's not something that you need to produce an expert to see. Everybody can see that the gas prices and the diesel prices have gone up a lot because of the war. The more critical question is actually this: by virtue of this war, and therefore the increase in prices of gas, diesel, and also other construction and the material. The question is whether or not the contractor will be able to recover some additional costs which it has had to spend on this. And actually, a lot of it will depend on the contract, especially if you're talking about a common law jurisdiction contract in Singapore, Malaysia, because this war here potentially could be considered a force majeure event. But if it is not defined as a force majeure event, then technically speaking, this rise in prices is not something that the contractor can claim additional monies or even time for. And in a lot of the force majeure clauses that I've seen in the contracts where force majeure clauses are present, the war or insurrection, rebellion, or whatever it is actually by reference to the country itself. So if you're talking about a Singapore contract, you're talking about war in Singapore stopping or rather causing all these prices to rise, which seems a bit silly, because if there's a war in Singapore, then obviously nothing will go on. So these type of things have to be, you have to look at the consequences of these events in the contract itself, especially in a common law contract. I think in Vietnam law, if they prescribe force majeure to be certain types of events, perhaps that would give relief by force of law itself, right? But that would be quite different from situation in a common law country.
Can I just ask one more thing?
Yes.
Continuation to what she asked. In India also,
during COVID-19, the claimants, the contractors were given relief by way of loss of time, and apart from that, the loss they suffered due to the labor being sitting idle or labor being transported to their hometowns, and so that also was granted. But other than that, of course, the claimants, they made their claims, the contractors made their claims for EOT was not an issue, it was granted straight away. But the prolongation claims also they raised. So in some cases they were granted, in many cases they were granted. What was the outcome of those claims in Singapore and Vietnam around this area?
Well, I can answer for Singapore. Again, COVID-19 is considered a pandemic, or a very serious epidemic, as I understand it. In this kind of situation, again, you have to look at the contract, because Singapore law, common law, doesn't just give you automatic relief just because there's a pandemic or epidemic, right? So in contracts where there's no force majeure provisions, or where contractor is not given relief because of pandemic or epidemics, the contractor takes those risks, which is why the Singapore government, recognizing this, actually has to enact by law certain temporary provisions that actually apply to help the contractors. So there's this very famous legislation called COTMA, which I cannot even remember what it's called. I think it's COVID-19 Temporary Provisions Act or something like that. So to actually provide for relief to the contractors, it says that employers must share in certain types of costs, and it actually even provides relief against any calls on calls on performance bonds. So it says that during the term of the operation of this act, employers cannot call on the performance bonds or demand bonds issued or procured by this contractor. So that's how that shows quite clearly that common law doesn't provide the relief. Legislation has to be enacted to provide the relief.
So I can share some point from Vietnamese law perspective. So actually the situation also quite the same to what Mr. Ho Chi Minh just elaborate, because whether you can invoke force majeure event as a court for exempting the obligation or not will depend a lot on the factual situation. So for example, like if you in Vietnam, right? Because of COVID-19, between Hanoi and Ho Chi Minh City, there was some period of time we are banned from getting out of our house. So if the claim is a delay for payment, then actually it is not justifiable, because everyone knows that with a token and with a laptop you can still work from home, and there is no how to say, like cost-sharing between the fact that you need to stay at home and work at home, with the consequence that you cannot make the payment in time. But if the claim is from the contractor, for example, for being exempted from delay damage, like the defense should be the defense for the contractor to say like I should be exempted from the delay damage because due to the government ban, we cannot deploy our worker to the construction site. Then I found that there would be a causal link in that argument, and if the discovery result in the fact that the area of that company or that construction site is affected by the government ban, then that perhaps the defense perhaps is valid. Yeah. So I so we talk about the force majeure. Now we talk about a little bit about the procedural issue. So Mr. Sang, your presentation focus on parallel proceeding, and you did examine the ICC arbitration rule. So do you think and you know, like SEAC introduced the new version of SEAC arbitration rule in 2025, and it was the first time in history in SEAC history it introduced the concept of coordinated proceedings. And I understand that the intention of that concept is also to deal with parallel proceeding or the issue of multi-party, multi-contract. So do you think that Rule 17 on coordinated proceeding under the SEAC rule of arbitration would be able to solve the problem that you raised in your presentation?
You mean the kind of the code arbitrators, right? Kind of, right? Because the problem is like kind of the parties agreement, because like the parties in the multi-contract and multi-party kind of have a different interest, so they want to go another forum, something like that, because another forum will different arbitrators. So how we can consolidate something like that with different arbitrators, because just like kind of the maximum threes, it also depends on the agreed by the party arbitrator. If even though different figures also agreed by the party, so the techniques can be invoked here. Okay, party agree in advance with the same arbitrators, even they already go further another forum, kind of a different forum, but like if they don't have agreement like that, so this also the problem. Also problem in 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 the one situation really concern me regarding kind of like employer, the relationship between employer and contractor. Kind of many contractor kind of claimants file lawsuit against employers. If all claimants don't have agreement, like a mutual agreement on arbitrators appointments. So one is how we can handle it. SEAC rules allow the authority to president of the Singapore Coast kind of SEAC to handle if the claimant don't agree and cannot have a mutual agreement on appointment of the arbitrators. So I think it's also the solution, but now the techniques is also can be applied to Vietnam, because I already see the VIAC rules calling for the submission, like a contribution to revise their own VIAC rules. Kind of next edition will be 2026. I remember because I just see on the website of the VIAC, VIAC call for revisions edition 2026. They can add and modify their provision kind of party should agree in advance. Party in advance about if in case claimants kind of have no mutual agreement. Okay, they let employer to determine the arbitral tribunal. So the relationship between the employer and contractor. So kind of that's kind of the ideas. So you can do it. And if in case the claimant between them among all of them cannot have a mutual agreement in appointing arbitrators to submit to the SEAC court. So Okay, so you let that authority to the president, but I think employer and contractors can be having uh, postman of the arbitrator agreement in advance. If the claimant cannot have a mutual agreement in appointment of the arbitrator, so you let authority to the employer. So that's also the technique. Okay, I trying to make research. Yes.
Thank you, Mr. Sang. That emphasize for the rule that dispute prevention is more important than dispute resolution. So if you can draft a contract well and incorporate the coordinated proceeding rule or the alignment on how to appoint the arbitrator and grab it very clearly in the contract, then you will be able to avoid some dispute later on. Yes, so I would like to give the last question to Dr. Hazet, and I bear in mind that we are close to 12:30 and everyone want to have a lunch soon. The topic that Dr. Hazet presented today is very interesting because the issue of pre-award injury and post-award injury is often underestimated in an arbitration proceeding. So I would like to ask this question. What is the typical injury rate for pre-award injury, provided that the currency of the awarded damage is USD, United States dollar, uh, and and second question would be the question of how to determine pre-award injury rate will be governed by the law of the seat of arbitration or procedural law or the governing law of the contract of dispute substantive law.
Okay, so basically, if it is you know a global contract, that's what I understood from your question. If it is a global contract, international contract, and then what is the rate of interest? Whether the interest will be barred still, yeah? Okay. And then if it's not barred, then what is the rate of interest, right? Okay. Now, as far as the international contracts are concerned, generally in Indian, contracts, Indian public body contracts also, the interests are not barred because otherwise the competition will become very scarce. So normally the interest is not barred in global international contracts. Now, if the global contracts are governed by the Indian law, that is the Indian Arbitration Act. So Indian Arbitration Act that way is very flexible. It gives full freedom to the tribunal to grant whatever rate of interest it deems reasonable for on whatever amount it thinks, or the tribunal in their opinion decide that this is the amount which was long overdue to the contractor. So therefore the interest should be given or awarded on this, and also the period. It could be right from the day of the cause of the action when it arose, or maybe some days later, some years later. It's that flexibility is there in the Indian contract. In some of the contracts, like there were international contracts in directed freight corridor of India, and also in high speed, the rate of interest is actually fixed because it is the same. That way the contract is very equitable, I would say. The whatever interest they charge to the contractors for advance payments, the same rate is given for the delayed payments also. It is prescribed. The rate of interest is also prescribed. Thank you.
And yes, I think because now it's already past 12:30, I would like to close the session here. Unless any one of you have any further question to the speaker. Yes, please. Please.
This issue, which is the impact of fuel globally. When you have an article as though a single code country map, which includes Vietnam, you usually have a provision dealing with the concept of unforeseen change of circumstances. And unlike force majeure, which is obviously an excuse for non-performance in case your performance is impossible, this concept of unforeseen change of circumstances, which is included in Article 420 of the Civil Code here in Vietnam, allows obviously the possibility to renegotiate or even terminate the contract. Is that something that you have seen being used in the context of COVID claims, for example, and whether you see the possibility to use that sort of concept in the foreseeable future with, you know, increases in the price of fuel here in Vietnam? Because I've seen it, for example, in France, this has been successfully raised to renegotiate contracts and even terminate contracts. And that was in context of COVID claims. And you can see exactly the same consequences here.
Yeah, Mr. Frederick raised a question for Vietnam, but actually before I share my insight for Vietnam market, I would like to hear from you because that directly relate to your presentation.
I mean, I can tell you the common law position. There's no such thing as
just
renegotiation.
ignore common law.
Yeah,
no, really,
exactly.
because this is the key. One of the key distinctions between common law and civil law, where
Yeah.
force majeure exists as an excuse for non-performance, so no additional cost can be claimed unless it's provided for in the contract. But that's a remedy at law which allows a party to renegotiate or claim additional costs. So that's one of the key benefits of civil law countries.
Yeah. So I mean, common law is quite black and white. Is it in the contract or is it not in the contract? That's it.
Yes.
In India, in similar, especially in the context of COVID-19 situation, the Indian government, as I told, the extension of time was no issue at all. A lot of compensation was given by way of the, on idle labor or labor being sent home. With some of the contracts, the issue of claim was taken under change of law, which permits the compensation. So that also helped the claimant parties a lot. And this was done through a government order. So I think it didn't create much of a problem.
The issue we face obviously is not change in law like we had with COVID, with lack of, the quarantine time and so forth, airport being closed and stuff. So it's very much the direct impact of the spike in gas fuel and prices like this. So it's in your case in the Middle East, I think that's probably something that could be explored.
Yeah. So under the law of Vietnam, especially the civil code of Vietnam, I think there are two principles that you can rely on to kind of like architect your argument related to the gasoline or COVID or gasoline price increase or COVID or war. The first one is force majeure event. Civil code does provide a provision for force majeure event. The second one is the second one is like fundamental change of the circumstance. But the idea of the civil code is always that the parties the party agreement will prevail the law unless the party agreement contrary to kind of like the principle of Vietnamese law and the exception does not work in this case because for force majeure and and fundamental chain of circumstance provision. There is no prohibition from the law. So if there is any variation in the parties' agreement, then that variation will prevail. So it means that we also will adopt kind of like similar approach with common law, which is that we need to explore what is spelled out in the contract, and I think like based on my experience, most of the contract with a big value in Vietnam will adopt a clause for force majeure. But what often unclear the most is about the prior notice period, like whether a party failure, whether the impacted party failure to observe the prior notice period for the force majeure event or fundamental chain of circumstance to the remaining party will forfeit, will make him forfeit his right for the exemption of liability or exemption of obligation. So that is often the most part of that the party argue the most, like whether the mere failure of the procedural notice would result in one party's forfeit of the right or unentitlement to the right for a liability exemption. And for that part, each tribunal and each court will view differently. I saw some arbitral award. They concluded that the failure to observe the procedural to observe the procedural notice will make the party lose the right for liability exemption. But I also see some other judgment and tribunal award which say that which say that the failure to follow the procedural notice does not automatically take away the right of the impacted party for liability exemption. So like in Vietnam, we do have a case precedents, but currently I don't see any case precedent directly deal with this issue, and the issue continue evolving. So we would need to see if in the future there will be the Supreme Court of Vietnam will adopt any case precedent directly deal with this issue. Is that clear? Thank you. Yeah, so I would like to invite all the speakers for a picture before we head to lunch. Thank you.
On behalf of the organizer, we will give the speaker or monitor certificates.